Following the Office of Attorney General of the Federation that has now filed the defamation charges against Senator Natasha Akpoti-Uduaghan for allegedly violating provisions of the Penal Code through remarks directed at Senate President Godswill Akpabio and the former Kogi State Governor Yahaya Bello. Are now joined from Benin City, Edo State, by Elvis Asia. Elvis, before the break, I was asking you that the charge states that Senator Natasha Akpoti-Uduaghan made an imputation, and that's, quote, knowing or having reason to believe that such imputation will harm the reputation of a person, end quote, under Section 391 and punishable under Section 392 of the Penal Code law. How is having reason to believe legally interpreted in Nigerian jurisprudence of this offense, or for this offense?
Okay, thank you for having me on the program. I was saying that the senator, it's the senator of the Republic, so she has enough knowledge and information to know that know the limits of statements that could be made publicly. When you say there's a likelihood, it simply means that you have made a statement that could be interpreted in a manner that would tarnish the reputation of someone under the Penal Code. For me, the question is not really about the interpretation of that phrase, but basically the circumstances surrounding this particular charge and whether it meets, constitutional validity. Particularly looking at the fact that there's also another pending defamation charge filed at a different court under the cybercrime legislation, which I believe is the reason why the lawyers have raised an objection now, seeking to say that this appears to be a political witch hunt, multiplicity, abuse of process, because of the way and manner the charges have been filed in different places. But I think what's important is that there's a limit. I mean, we have to be very clear as much as we want to ensure that the office of the Attorney General is not abused in a manner to seeking to protect the image of someone. I don't think that's what the office of the Attorney General should be doing today. There are so many important cases that should be checked. But I haven't said that there is a limit to what you can say and what you should say or what you cannot say.
Right.
Even your right to freedom of expression has some limits. I believe that is what is playing out for the court in the charges that are being filed.
Right. I mean, given that the alleged statements were made in a televised interview and comments about, public officials, how might the defendant argue protections under the freedom of expression in the Nigerian Constitution?
Well, I mean, I've just said that the freedom of expression has constitutional limit. And the Penal Code, particularly Section 391 to 392 or 395 or thereabouts, has provision which is still part of our laws in the FCT, and that has been filed. I'm not aware of any case where that provision has been struck down as being unconstitutional. And so there's still a possibility for those kind of charges to be filed in the FCT, even though I feel that it's not a wise use of our resources and the Office of the Attorney General. Defenses that the Senator Natasha may want to look at would be, those statements were made in public. She alleged that her home was invaded in her state, and she linked it to the political development that was going on between her and the Senate and the Senate President, as well as the former governor of Kogi State. And so, but at this point, we haven't even got to that point. They are basically raising the point about the validity of the charge itself, and so the issue of the merit of the case, or whether or not there was indeed a defamation that is, exposes her to criminal liability under the Penal Code. That's not even arising at this point. At this point, the question is whether or not the charges are actually valid, whether there's an abuse of process, because it will appear that it is the same allegations that formed the basis of another charge file pursuant to the cybercrime legislation. Why it is possible for you to have, for the same set of facts to give rise to different offenses under different legislations. I would think that it's probably best, in circumstances to have, one prosecution, so that it doesn't sound like persecution, as many people perceive it, considering the political undertone and all the things that's going on, that's gone on, and the drama so far between the Senator and the Senate President.
I'm glad you're raising concerns about the AGF's office, following this case, because, since the AGF has insisted that these charges were not an abuse of court's process and were brought after investigations, how does the defense how would they be able to effectively scrutinize or challenge the exercise of prosecutorial discretion?
Well, it would. First, let me quickly say that in our experience in Nigeria, it has become it's creating a lot of problems, because the office of the Attorney General is supposed to be an independent office, someone who is committed to defending the Constitution and exercising discretion in the interest of the people. But what we have is that the office of the Attorney General in Nigeria is a political office. It's also the Minister for Justice, and so at the end of the day, the office of the Attorney General has become a tool, to protect the political expediencies of those who, occupy part-time. And that is where we have the challenge. But coming back to the issue of proof, I think it will depend on how the court sees the facts and circumstances of the case. Everything is factual. Lawyers, people can speak a lot of grammar, but what it comes down to is a matter of facts. The court will look at the facts, the charge filed in this particular case and the other charge, and then look at the whole circumstances to see whether it could be said that this amounts to abuse, or really amounts to prosecutorial misconduct, or witch hunt, or some form of attempt to silence the senator. It's going to depend on the facts of the case. I can't sit here now and tell you what the outcome is going to be. That will not be allowed. But what I can say is that the court is going to weigh the charges and look at the substance of what the defense is saying. But I can say that it will appear that what the defense is saying might mirror public perception, the information out there. If someone makes an alleged defamatory statement, and I filed a charge. I believe the reason why they decided to file this charge is because the Cybercrime Act was amended, Section 24 was amended in such a manner that defamation is really not specifically a crime now under the Cybercrime Act. Right. So perhaps is the reason why they decided to now shift their focus to the Penal Code in a desperate attempt to ensure that the senator is, in quote, dealt with.
Could the defense raise a constitutional argument about misuse of criminal defamation laws to stifle legitimate political speech, given the Penal Code there?
Well, the arguments are open to the defense. The defense is able to, argue very strongly that, looking at the facts and circumstances of the case, these charges, are basically attempts to stifle senators, right to free speech, particularly political speech. And, let's even be real. Within the Nigerian political system, we have come to terms with a lot of stories, allegations being made, counter-allegations being made, which may not really be taken that seriously by members of the public in terms of factuality and all of that. That is something that's open to them. But on the side of the prosecution, they will argue that, well, yes, the right to free speech is there, but it's not something that you can. There's a limit to it, and Section 45 of the Constitution prescribes those limits, which allows the National Assembly to make laws. But it can be argued that those laws must also be must be consistent with the democratic society. But unfortunately, I'm not aware of any appellate decision that has said that has set aside those relevant provisions. So perhaps this might be an opportunity for those arguments to be made, and it will be good for our jurisprudence. I think a proper court needs to really examine, the way and manner we dissipate our resources in pursuit of defamation to pursue somebody's reputation. It's not like, it's not the case of we're trying to protect an institution, protect the National Assembly, protect the presidency, or whatever, but just somebody who feels slighted by a statement that somebody has made. I think it's an opportunity, and I hope that, this will be properly adjudicated upon. There will be proper decision on it, and that may go all the way, perhaps to the Supreme Court, so that we can, really define the scope of the powers to criminalize defamation.
All right. I must say thank you, Elvis, for taking out the time to join us there. Elvis there. He joins us live from Benin City, just giving us a bit of insight following defamation charges against Senator Natasha Akpoti-Uduaghan.